A $10 million villa on the Mediterranean. Sea views, infinity pool, a deed with your name on it. And none of it legally yours. Every year, wealthy buyers wire fortunes for luxury properties abroad, only to discover forged titles, unregistered land, or heirs with legal claims no one disclosed. The villa looks flawless. The ownership trail tells a different story. And most buyers never check until the money is already gone. In 2025, an unsuspecting buyer targeted a luxury villa on Spain's Costa del Sol. She wired millions of euros, signed the paperwork before a notary, and received a registered deed. Weeks later, she discovered the real owner had never agreed to the sale. To see how this happens, we must look at how ownership is tracked. A deed is simply the legal document that transfers property from seller to buyer. The title chain is the documented history of everyone who has ever owned that specific parcel of land. If every single link in that chain is solid, the transaction is safe. But criminals target the weak links. In this case, scammers fabricated a power of attorney, a legal document that grants a third party the authority to sign contracts on the owner's behalf. Using forged identity papers, stolen passport data, and fake notarization stamps, the fraudsters made it appear as though the absent owner had authorized the transaction. Because local notary systems often rely on paper documents without cross-checking live national databases, the transfer was processed, recorded, and finalized. On paper, the buyer's new deed looked flawless, but because the underlying power of attorney was a counterfeit, the entire transaction was legally void from the beginning. The real owner retained full rights to the villa, the courts invalidated the transfer, and the buyer's millions disappeared into untraceable offshore accounts. The real danger is that the final document you sign can look perfectly clean, while the deeper history of the property is completely corrupted. Even when the seller is legitimate, the land itself might not legally exist as advertised. To protect a $10 million purchase, buyers must understand the division between the land registry and the cadastry. The registry proves who owns the property, while the cadastry defines the physical boundaries, size, and location of the parcel. When these two databases do not align, the legal footprint of a villa collapses. In Costa Rica, where official cadastral maps date back to the 1970s, outdated records create boundary mismatches in nearly 30% of transactions. A buyer might purchase a cliffside estate only to find their infinity pool sits on a neighbor's parcel, triggering litigation, forced demolition, or a complete loss of bank financing. The risk of unregistered land changes completely across borders. In Portugal, a major registry system failure in 2024 froze thousands of transactions in municipalities like Lule, leaving buyers unable to record their deeds on official government servers. In Mexico, the risk is communal ownership. Millions of coastal acres are classified as ejido land, owned collectively by local communities. Foreigners buy luxury villas on these parcels, believing they are private, but without a complex conversion process called dominio pleno, the sale is legally void. The community can reclaim the land, and the courts will order immediate eviction. A pristine physical villa is meaningless if the legal soil beneath it is completely unstable. A buyer walks through a $10 million villa, admiring a newly added rooftop terrace, an infinity pool hanging over a cliffside, or an entire guest wing built to capture the sunset. Visually, the property is a masterpiece. Legally, it may be a liability. In luxury real estate, what you see rarely matches what is registered with the local town hall. A composite case of a luxury purchase on the coast illustrates this physical to legal mismatch. The property looked perfect, but the seller had added a luxury guest suite and an expanded pool terrace without updating the original municipal building permit. In many resort destinations, a building is only legal if it possesses an official occupancy or completion certificate. Issued by the local municipality after an inspection, this document proves the physical structure matches the approved architectural plans. Without it, the property remains non-compliant. When a buyer relies on visual inspections rather than verifying the permit file, the fallout is immediate and expensive. Municipalities increasingly use drone surveys and satellite imaging to match physical properties against their registered blueprints. If they find unapproved additions, they can issue heavy fines or immediate demolition orders. At the same time, banks will refuse to finance a property with unpermitted structures, and insurance companies will deny coverage for any damage occurring in these illegal spaces. In Spain, France, and Italy, a seller's right to dispose of their property is strictly limited by a legal concept called forced heirship. Under these civil law regimes, a massive portion of an estate, up to 75% in France and 2/3 in Spain, is legally reserved for compulsory heirs like children or spouses. If a wealthy owner sells a €10 million villa and subsequently passes away, their estranged children or a previously unknown statutory heir can file a clawback claim. Under the EU succession regulation known as Brussels IV, the law of the deceased's habitual residence governs the estate. If the seller did not make a formal nationality election in their will, local succession laws override everything, including any foreign trusts or corporate structures. Marital status and local probate history also dictate who must consent to a transaction. If a seller is married under a community property regime, or if the villa was recently inherited without full tax clearance, heirs can challenge the sale years later. Local courts can rule the original transaction null and void to restore the mandatory share. The buyer is forced to surrender the property, losing their equity and facing a prolonged legal fight to reclaim their funds from a dissolved estate. Imagine a scenario where a forged deed, a registry database failure, unpermitted renovations, and a sudden forced heirship claim hit a single luxury property. The result is a total write-off, easily exceeding $10 million. To prevent this absolute loss, a strict transactional rule applies. Never wire a single dollar until 3 specific, independent investigations are complete. First, verify the seller's identity and actual signing authority, exposing any fake powers of attorney. Second, demand certified, original registry extracts to map the complete ownership chain. Then run comprehensive searches for hidden mortgages, bankruptcies, or outstanding tax liens. Third, hire an independent surveyor to conduct a physical GPS boundary check, ensuring the villa on the ground matches the official government parcel maps. To secure the structures themselves, buyers must audit the original municipal building permit file directly against the as-built architectural plans. Licensed architects or civil engineers must physically verify that every guest wing, terrace, and infinity pool has an official occupancy or completion certificate. Beyond the concrete, the seller's personal history requires an independent legal audit. Local probate courts and central will registries must be searched to confirm marital status, community property rights, and succession clearance. Finally, local experts must verify zoning, short-term rental permissions, environmental restrictions, and any outstanding municipal tax debts before the transaction proceeds. Securing a luxury estate requires controlling the flow of money. Never use the seller's lawyer Retain independent local counsel with a track record in high-value transactions to draft the purchase agreement. Instead of wiring funds directly to the seller, deposit them into a neutral escrow account. Structure the contract so these funds are only released after the local land registry records the deed and the municipality delivers the occupancy certificates. While local title insurance offers a secondary fallback, it cannot repair a corrupted title. Lastly, structure any corporate holding entities or trusts only after local legal consultation to make sure they match regional succession laws. This analysis is for educational purposes only and does not constitute legal advice. Subscribe to the channel to protect your global real estate investments. In global luxury real estate, prestige never guarantees safety. True wealth protection relies on relentless verification, not a premium price tag. Please consult a professional, as this educational guide is not legal advice. Subscribe for more wealth protection insights.